Yo, what's happening? What's happening? Can you guys hear me okay? Thank you. Let's see, Kathy, for becoming a new member. I appreciate that, love. Thank you so much. The live we had before this is on members only because I didn't want to further embarrass anybody. So I didn't leave it public. I can put it public if it need be, but I put it on the members only, which we have a lot of members anyways. So I'm sure most anybody that wants to see it can watch it. But anyhow, this trial is it's going to be a game changer, man. There's going to be a lot of cases that are going to be affected by this, and I think they're really reaching with this one. But to be honest with you, there's a lot of people, that can be affected by this. A lot of people in the rap game, a lot of people in the music game. Like this is if they can use your lyrics against you, and use it to run a conspiracy RICO, a trial RICO on on you with it, that's an issue. So that's a major problem. So we'll get started. Actually, they're about an hour late right now. Day one, they're an hour late. The juror didn't show up on time. So we're an hour and 1 minute in, and the judge comes in. So we'll start here.
Jurors are here at this point in time. Is that correct? Yes, sir. All right. All right. If we could summon our jurors for us, please, and Deputy, if you would have them, as we talked about earlier, not everybody except the last row. Yes. Okay. All right. Is everybody here? Everybody present? Mr. Sharp coming here. All right. Well, okay. I'm worried about him right now. Okay, but all right.
Now he's got a whole team of lawyers. I believe he's got like 6 or 7. But there's an entire team of lawyers up here.
George, please come forward. All right, ladies and gentlemen, please be seated. You got no chair? Yeah. Okay. No chair. No chair. Yeah. Yeah. Okay. All right. All right, all jurors present? Yes, sir. All right, okay. Good morning, ladies and gentlemen of the jury. Oh, come on, that sounds so lame. Come on. All right, let's try that again. Good morning, ladies and gentlemen. Good morning. Oh, much better, much better. Ladies and gentlemen, as you know, I'm Chief Judge Earl Glanville, and I'm presiding over the trial of this case. And at this point in time, I'm going to introduce my chamber staff. In the courtroom, I have my court reporter, Miss Christina Weaver. She's my official court reporter. And then to my right, your left, is Miss Violetta Romano, who's my judicial assistant. To my left, immediate left, is Mr. Wesley Kearns. He's my staff attorney. And then the gentleman you just brought you out is Sergeant Tim Ingram. So, and then I have another litigation manager upstairs, Edward Chamberlain, and you'll meet him at some point in time if you haven't met him already when you were here before. So, as I mentioned earlier, they're here to assist me and will be happy to help you in any way you can. Your principal point of contact, should you be running late or anything should happen to you or you need to kind of reach us before the time period. I understand one of you had a car issue this morning. So you all still have my cards? And if you don't, I got plenty more. We'll give you some before you leave today. If you're going to be running late or anything, please contact Ms. Umana and let her know so that I can kind of keep track of you and I can let the parties know where you are. But it is very important that you all get here on time. We were supposed to start at 9 o'clock this morning. It's now almost 10:30. So I can't do anything until all 18 of you are here. So please mind your time. Only you know how long it takes you to get from wherever you live in our great county, downtown, Fulton County, to the courthouse and all the machinations that you have to go through. So leave early. You can always come a little bit earlier and be comfortable and be seated in your headquarters at your deliberation room. Okay. All right. But at any point in time during recesses, you can approach my staff, or as I mentioned earlier, any of the people from our sheriff's department who are in the gray and black uniforms, you're authorized to talk with them. Before we get into preliminary instructions, ladies and gentlemen, I have some administrative matters to discuss with you. I've already introduced my staff, and I encourage you to approach them if you have questions. Remember, the sheriff's deputies have shown you how to get to the jury room, how you arrive here every day. Okay, so you're never to come into the front door of the courtroom. You always go in to the rear and go directly into your headquarters at your deliberation room. And from this point on, you're not going to enter the courtroom unless one of the deputies brings you out from the jury room. After breaks and the beginning of the day, when you arrive, you'll go straight to the jury room. And our deputies, as I mentioned earlier when you were here a little bit earlier, give you the nickel tour of the courthouse. So all of you know how to get from the front entrance up here to your headquarters. Is that right? Okay. We talked a little bit about meals and how you can, there's a cafeteria that's directly behind you. We talked a little bit about that. Since you were here, you like the space back there?
Yes.
It no longer looks like a dump. We painted it, got you some fresh tables, chairs, and a couple of refrigerators, a microwave, a coffee pot, and we'll make sure that we go ahead and make sure that is cleaned and maintained for your use. I want you to be very comfortable while you're in there. But as I mentioned to you earlier, it might be better just to bring your lunch or bring your comfort items, but we'll make sure that you have some place to store them and otherwise can warm up your lunch if you feel necessary. All right, I would ask that you wear your juror stickers when you're here in the courthouse, and all of you have juror stickers, wonderful. If you don't, when you go back in there, put one on, and remember at the end of the day, take one, put it in your
Damn, he's talkative as hell, ain't he? Shit, that's the most talkative I've ever seen a judge.
wallet, your purse, your briefcase, whatever you may have, and put it on when you come back in the courtroom, in the courthouse. This is so the lawyers and the witnesses can identify you as a juror. From this point on, the lawyers, the parties, the witnesses, or anyone else associated with this case, except for my staff or our sheriff's deputies, was prohibited from having any contact with you whatsoever. If you happen to encounter any one of them on the street or in the elevator, please do not attempt to communicate with them in any way and do not be offended, as I mentioned to you earlier, if they ignore you, okay? They're just adhering to their responsibilities and roles as officers of this court to not have any direct or incidental contact with you. So please don't be offended. If you should some reason have contact with one of the lawyers, or if you inadvertently overhear something about this case, please notify one of my deputies or my staff immediately. Now, this also, ladies and gentlemen, pertains to third parties or anybody else that may try and talk with you. If anybody else, other than the folks I told you about, the lawyers, attempts to talk with you in any way, emails you, texts you.
Yeah, and there's his co-defendants are sitting back there too. With the RICO Act, they're all being accused of it. We also got the lawyer you may know. So the lawyer y'all want to know, he talks about it too. So we'll pop him up too.
Tries to communicate with you when you're going to and from, we need to know about it immediately, okay? So please tell me if that should happen. We generally hold court from 9 a.m. to about 6 p.m. or thereabouts. We'll take some short comfort breaks as needed throughout the day and a longer break for lunch. And for the sake of your fellow jurors and the parties, as I mentioned earlier, please make every effort to be on time, as we cannot begin or continue the case until all 18 of you are present. If something unexpected happens and you absolutely cannot help being late, please call my office and contact Ms. Umana.
It took them an entire year to pick out the jury.
And she'll let me know and let us know accordingly. All right, ladies and gentlemen, now I'm going to cover some basic principles of criminal law. I'm going to explain my role, your role, and the lawyer's roles. And then finally, I'm going to tell you how the trial will proceed. Since many of you haven't served on a jury before, so this should help you in understanding how a trial proceeds and what is expected of you during the trial. Now, you've been selected and sworn to try the following: the criminal case of the state of Georgia versus Marquavius Huey. The Fulton County Grand Jury has indicted the defendant Marquavius Huey with the following offenses, which I'll read to you: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, armed robbery, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, possession of a firearm during the commission of a felony, armed robbery, aggravated assault with a deadly weapon, hijacking a motor vehicle in the first degree, possession of a firearm during the commission of a felony, participation in criminal street gang activity, possession of a weapon by an incarcerated individual, possession of a telecommunication device by an incarcerated individual, and participation in criminal street gang activity. The criminal case of the state of Georgia versus DeMonte Kendrick.
Damn, they racked them motherfucking charges up, Jack. Boy.
The Fulton County Grand Jury has indicted the defendant, DeMonte Kendrick, with the following crimes, which I'll read to you now: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, murder, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, possession of a firearm in the commission of a felony, possession of a machine gun, and possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Quamarius Nichols. The Fulton County Grand Jury has indicted the defendant, Quamarius Nichols, for the following crimes, which I'll read to you now: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, murder, participation in criminal street gang activity, possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm, possession of a firearm in the commission of a felony, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Rodeus Ryan. The Fulton County Grand Jury has indicted the defendant, Rodeus Ryan, for the following crime, which I will read to you now: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act. The criminal case of the state of Georgia versus Shannon Stillwell. The Fulton County.
Okay, these are not all just his charges. These are his co-defendant charge. They're all getting charged with the RICO Act, which means racketeering. They were all together. They did this together. They co-conspired together, is what it's being alleged. So these are him and his co-defendants. These are their charges as well.
The grand jury has indicted the defendant, Shannon Stillwell, for the following crimes, which I will now read to you: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, murder, participation in criminal street gang activity, possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm, possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Jeffrey Williams. The Fulton County Grand Jury has indicted the defendant, Jeffrey Williams, for the following crimes, which I will now read to you: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, possession of a firearm in the commission of a felony, and possession of a machine gun. Each of the defendants have pled not guilty to this indictment, and each of them deny every charge in it. This indictment and the defendants' pleas of not guilty present the issue that you've been selected and sworn to decide. The indictment is the way the defendants are charged with committing crimes that violate the laws of Georgia. The charges in the indictment and the pleas of not guilty are not evidence of guilt, and you may not conclude the defendants are guilty based on the charges or the not guilty pleas. Each of the defendants is presumed to be innocent until he is individually proven guilty. The defendants begin the trial with a presumption of innocence in their favor, and this presumption stays with them until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendants are guilty of the crimes charged. You may not convict any one of the defendants of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment beyond a reasonable doubt. The defendants have no burden at all, and the burden never shifts to any one of the defendants to prove his innocence. However, the state is not required to prove the guilt of the defendants beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which you can give a reason based on a consideration of the evidence or a lack of evidence, a conflict in the evidence, or any combination of these. After considering all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is the doubt of the law, and you must find the defendants not guilty. But if no reasonable doubt exists in your minds about the defendant's guilt, then you may convict the defendants. If the state does not prove the defendant's guilt beyond a reasonable doubt, your duty would be to find the defendants not guilty. My role is to determine the law that applies to this case. Then I will instruct you on the law that you must apply to the facts in reaching a verdict. I'm giving you some of those instructions now. I will give you more detailed instructions at the end of the trial. The jury has a very important role. You must decide the facts of the case from the evidence presented and then apply the law that I give you to those facts. Evidence is how a fact is proved or disproved. Evidence can be either testimonial or exhibits. Testimony is what you'll hear from people who take the witness stand right here and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. Exhibits are documents, photographs, and other physical items that are admitted during trial. The object of this trial is to discover the truth. During the trial, I will admit evidence according to the rules of evidence. Those rules are designed to aid in discovering the truth by making sure that you consider only the best and highest evidence. The lawyers are advocates for their clients, and they have the duty to represent their clients to the best of their ability. They must follow the rules of law, trial procedure, and evidence during the trial. They may make motions or objections if they believe that any rule is not being followed. Remember, what the lawyers say in making or responding to objections is not evidence. I will admit or exclude evidence according to the rules. If the lawyers make an objection and I overrule it, that means the evidence is admitted and you may consider it. On the other hand, if I sustain an objection, this means the evidence is excluded from the trial and you may not consider it. You should consider only that testimony and only those exhibits that are admitted. You should not assume or infer anything about evidence which I have excluded. If you happen to hear or see evidence that I end up excluding from the trial, you must disregard it entirely in your deliberations and in arriving at your verdict. None of my decisions and nothing I say during the trial are evidence. My decisions and remarks do not mean that I favor or lean to one side or another in this case. I am only interested in seeing that this case is fairly tried based upon the laws and Constitution of the state of Georgia and the Constitution of the United States. Sometimes I may have to deal with the lawyers' motions or objections without you being here in the courtroom, and so I'll excuse you from the jury room. So what I'll say, ladies and gentlemen, there's a matter we need to take up. If you retire to your headquarters or jury deliberation room, and I'll wait further instruction. That's my most artful way of telling you we need to take up something outside your presence and hearing, okay? I'll try and limit those interruptions, and I ask that you be patient when they do happen. I can't tell you when those will happen, but sometimes they do. So please I'll ask for your patience in advance on that particular matter. So the trial will proceed as follows. First, the attorneys may give what's called opening statements. No attorney is required to make an opening statement. Opening statements are not evidence. They're simply an introduction to the evidence, a preview, or an outline of the expected evidence. The state goes first because they have the burden of proof. Second, the evidence will be presented. Third, the lawyers may give closing arguments or summations. They may discuss the law that applies to this case and how you should consider the law in light of the evidence. They may also point out evidence that they believe supports their position. What the lawyers say in closing arguments is not evidence. The goal of a closing argument is to persuade you to decide the case in their favor. Fourth, then I will explain to you the specific law that applies to this case. This is referred to as charging the jury. I will then ask you to go to the jury room, your headquarters, to deliberate and to reach your verdict. It is important that you pay close attention during this trial. If at any time you cannot hear or see any evidence or you're suffering from any discomfort that distracts you, please inform me or one of my deputies or my team, and we'll do whatever is needed to make sure you can hear and see the evidence and give it your undivided attention. If you need a break at any point in time, please raise your hand or alert one of our deputies. The jurors are not allowed to question witnesses. However, if you have a question you believe is important for your determination of facts, please write down your question, give it to one of the deputies, and I will determine whether or not it should be asked. If you have a question while the evidence is being presented, please keep in mind that you do not yet heard all of the evidence, and your question may be answered by the time the rest of the evidence has been presented. You should only consider evidence with you should consider the evidence with an open mind, and you should not reach any final conclusions until the trial is over. Do not jump to conclusions before all the evidence is presented. To maintain the integrity of the jury system, I'm going to remind you again, remember my ad nauseum admonitions? Okay, y'all shaking your heads like, okay, we're going to go through those one more time. I'm going to remind you that you must decide this case only based on the evidence admitted during the trial and the law I will explain to you. You may not conduct any research on your own about this case or about any people or places mentioned during the trial. You may not visit any places mentioned in the evidence. You may not refer to any books or documents that were not admitted during the trial. You may not use any dictionaries or other reference materials. You may not use Google or any other search engines or any other resource matters, the internet, websites, or blogs. You may not use any other electronic media to get information about this case. You should not use any of the sources to get any information about the legal terms or about the law. And finally, you may not listen to any accounts of this trial that may appear in the news media, whether it's online, in print, on the radio, on your cell phones, or any other smart devices that you may have, or any other mediums. Remember, you are the ones that have been qualified as fair and impartial jurors deciding this case. No other influence should affect your decision. For that reason, as I mentioned earlier, part of my admonitions, you may not discuss this case with anyone, including your family and friends, or let anyone discuss this case with you or around you or in your presence. This includes discussing or sharing information by email, text, blogging, or other form of social media until actual deliberations begin. That is, until after you've heard all the evidence, the lawyer's closing arguments, the law that applies to this case. You must not discuss the case even amongst yourselves in the jury room, during breaks, or elsewhere. Remember, I told you, would it be a violation for you to sit back in your headquarters jury deliberation room after we take the first witness? Hey, what do you think? That a violation? Yes. Come on now. We all got to kind of shake our heads. Yes. Would it be a violation for you to be, as you're walking lunch, to recap and discuss the case? Yes. What about you in the bathroom? Yes. That's creepy. Remember, I told you about that before? Okay, all right. So we're not going to do that, all right? But what about going to the jury shuttle? Yeah, that'd be a violation as well, okay? What about if you're walking on Wednesdays and Tuesdays? Yeah. All right, okay? And how did I tell you you're probably going to get caught if you violate my admonitions? You're going to tell on yourself, that's right. Or somebody's going to tell me that you've been on some particular site or some particular issue. You ought to really learn that. Okay, I'm proud of you. All right. But it's really important, ladies and gentlemen, because remember I told you, fair trial, just trial, lawful trial. So all of these things are really important in terms of the admonitions and how serious we are about you not being only hearing what's in this courtroom and only the cases presented to you. All right. So you've been given pencils and writing utensils and pads for your notes.
They got pencils, writing utensils, pads, and everything. Shit. That's it. That is it. Here, I'll drop the link in case anybody wants to come up. We'll pause it and talk some shit throughout it, or we can just watch it. It really don't matter. I just want to get caught up real quick so we can get to the good parts, because there's some really good ones in here.
Note taking and use during this trial. So what I want you to do at this point in time is,
also, the prosecutor, she fucks up the opening statement, and she's about to come out with it. So get ready for that.
Take and open your pad to the very first page. For those of you that have them, okay. For the rest of you, I'm going to get your pad. All right.
Like do. How long does it take?
Okay, so everybody have a pad
of paper out?
Okay. Okay. All right. Who else doesn't have a pad? Do we have enough, or we'll get you one during the break. What I need you to do with all of you that have pads, go ahead and write your name on the very first page. Okay, that's your pad. Okay, so whenever you come back in, each after breaks and everything else, don't if you're going to your headquarters, just leave your pad inside the basket, okay? We're not going to take a look at it, and nobody's going to bother with it. Who else needs a pad? Everybody got a writing utensil? Pen or pen or pencil? Okay, for those of you who go ahead and who just got pads, go ahead and write your name on the very first page, inside cover. Just go ahead and write your name on it. And believe me, we have more pads, so if you get, by the time the trial ends, if you need another pad, we'll give you another one, okay? So, but leave them in your headquarters when you have breaks and go outside and for the end of the day. Just put them in there, take another juror sticker out, and that'll be kind of your way to kind of just trade and make sure don't take them home with you. Then the next morning you can find your pad and you can kind of just be prepared to take notes. Okay. So, I'm going to tell you that again, just leave your pads as you have breaks and everything else in your headquarters. And at the end of the day, like I said before, we will secure your notes. That'll probably be Miss Romano's job, and we'll just leave them in the basket, and we put the basket in your location, and then we bring the basket back down. So you all, when you come back tomorrow morning or whatever morning you come back, you'll have your notepad. All right. Now, but please keep in mind. All right, you may take notes if you wish. If you do take notes, please do not let your note taking distract you from paying full attention to all the evidence and the witnesses. You may not share or discuss your notes with anyone until you start deliberating at the end of the case, and I tell you how you're to begin your deliberative process. Notes are not evidence. They're only memory aids. They are not more important than your own impression or memory of what the evidence may have been. You may consider another juror's notes to refresh your memory. You should only rely on your own memory of the proceedings. Do not be influenced by the notes of other jurors unless their notes help you in determining your own independent memory. You must leave your notes in the jury room except when you are in the courtroom. They will be collected by the court and destroyed at the end after you finish your deliberations. Ladies and gentlemen, you will not get a transcript of any witness testimony, so please remember what's said on the witness stand in a way that works best for you, okay? I'm going to tell you a couple other administrative, or as I call, administerium. Ladies and gentlemen, I've tried a lot of jury cases, so some of the things I'm going to say to you are the result of debriefing a lot of other citizens. One of the questions I get on a routine basis is, Judge, what are you doing up here on the bench? All right. So I'm going to demystify that, and I'm going to tell you right now. So there won't be any question about what I'm doing. Okay. All right. So as I told you earlier, I'm responsible for just about everything that goes on in this courtroom. So on the bench here, I do have a phone, and I can make certain phone calls I need to. These devices here, ladies and gentlemen, you're going to see us use them from time to time. They are audio devices that each pair of litigants has on their table to allow them to hear bench conferences, because I may have to take up things out that I told you outside your presence and hearing, but we may not want to put you out of the courtroom. So we may come up here, I cut my microphone off, and everybody using these devices is able to hear the bench conference that I'm having. Will you be able to hear the bench conference? No, that's not for you to hear. So, but these devices allow us to do that. So if you see people putting on these particular devices to talk, such as this, you'll know that that's what's going on, okay? All right, to my left, I do have a computer. I have a couple of different programs that are open that help me do legal research and other things to keep track of what's going on during the trial. And otherwise, I'm taking notes. So if you see me typing, don't assume I'm booking my next vacation. I could probably be doing that, but I'm not. I do take notes, and I do pay attention to what's going on. Of course, I'm very interested in your comfortability, and I monitor everything that's going on here in the courtroom. So that's what I'm doing up here on the bench. All right. One other thing that you might hear behind me is this bell that starts jingling. All right. And if you hear a jingling sound like a bell, please don't think that I'm doing anything creepy up here. All right. I have a service dog behind me. His name is Jack. I think some of you may have seen him already. He lives the best life ever. He's pampered. He's really, and he is a Labrador Retriever. He's about almost 2.5, 3 years old at this point in time. So, but if you hear that bell, that's him moving around. All right. He doesn't bark. He rarely gets interested in what's going on. So he might come up here and look, but that's about it. All right. Don't bring him any food either. Okay. All right. He is spoiled rotten. So please don't try and throw any food back here behind me or anything like that. He doesn't need anything else. Okay. But if you hear that bell, hear that sound, that's what's going on behind me, and he'll get up when we have breaks and whatever else. So, but that's it. You hear the bell, that's Jack. All right. Ladies and gentlemen, I think we're ready for the lawyers to begin their opening statements. And what we'll do is we'll probably go till probably about 12:15 or so. And then whatever we don't get done, we'll just continue on at that point in time when you all come back from lunch. Okay? So at this point in time, counsels, I'm going to invoke the rule of sequestration as to both sides. So anybody who's going to give testimony in this case, if you please absent yourself from the courtroom, please don't discuss your testimony to anybody except the attorneys in this case. So at this point in time, does the state wish to make an opening statement? All right, go right ahead, madam.
Your Honor, I would ask the court regarding certain members that we have spoken with the court about in terms of witnesses, whether they are allowed to remain in the courtroom.
I believe the matter that we discussed, we won't be able to take up till Tuesday. So that person should probably be excluded. That person, if they're going to. But other than that, I think we've covered everybody else. Unless there's an exemption, do you have an exemption to the sequestration?
Your Honor, the family members of the victims themselves were the only ones that I'm concerned.
I'm not with them. There's no issue about sequestration as it applies to them.
All
right.
Excuse me, Judge. I have several objections to the court's opening charge. Would you either reserve those?
I'll reserve those.
Thank you.
Okay? All right.
Can I just make sure that all the witnesses are excused? Because I think there's been mixed messages sent by the attorneys, not by the court.
Okay, all right. Okay.
Your Honor, may I please approach the bench?
Say again?
May I please approach with the state?
Yes, Ms. D. Williams.
Okay, y'all. This is where shit starts getting crazy. It's gonna get entertaining. You ready for this? This is where it gets entertaining. So, yeah, just wait. She comes up and oh my God, it's a shit show. Get ready. It's a fucking shit show.
For those of you that wish to listen in, you can go ahead and do so. Good?
Okay, if y'all don't mind, I'm gonna fast forward through this because they're just up there chatting. Look at them. Look at them sitting there. Look at young Thug's attorney right there. Why does this remind me of B Tim? B Thug. Sorry, B Tim. I don't mean to clown you like that. I'm just saying this reminds me.
Okay, what? No, they should have just. Everybody gets at least one.
Witness.
You need 3 minutes, you said?
Your Honor, we just need to reapproach again, Your Honor, briefly, given that we just learned about this.
I'm going to exclude it for the time being, okay? Let's just move on. I'll take it up at another time. We're not going to take it up right now.
Thank you, Your Honor.
Your Honor, given that I have provided certain things, I just want to make sure that I comply.
Yeah, we could have taken that thing up about an hour earlier, but I'll take that issue up later.
Okay.
Yeah, so oh fuck, I got an echo probably. I'm sorry about that. Anyhow, yeah, so basically they tried to pull out some tricks there, and the defense wasn't having it. No, you got to share that kind of shit. When the prosecution comes out with something, they got to share it with the defense. You can't just pop that out.
Let me know when you're ready, madam. We're ready. Okay, all right. All right, if you wish to make an opening statement at this point in time, please go ahead. All right.
All right, here we go with the opening statement, y'all. Here we go. Here it is. Run it, y'all.
I'm going to now share my screen reports from the.
Yes, ma'am. Go right ahead.
Now, this is the law of the jungle, as old and as true as the sky. And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law runneth forward and back. But the strength of the pack is the wolf, and the strength of the wolf is the pack. Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today, during the voir dire process. I appreciate you all being here, exercising your civic duty, and honoring your obligation to pay close attention to what's going on in this courtroom for the next several, however many weeks. Some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with the evidence for the next several weeks at least. And you will be able to see what that evidence is. Nothing that I say to you during this part of the trial, and nothing any other attorney says to you during this part of the trial is evidence. But I can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognizes it, those were running out kept.
How the fuck you gonna open up the YSL RICO trial with the motherfucking line out of Jungle Book? Fucking stop.
Kipling's words and not mine.
Bitch, I can't take you serious.
But where we are today. For 10 years and counting, the group calling itself Young Slimelife dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started
Not
out
the
as
Jungle Book.
called Rock Crew. And Rock Crew stands for Raised on Cleveland.
I can't believe she really just pulled it on Mowgli. Oh, Mowgli. She sure did.
The evidence is going to show you that Rock Crew in fact, is a criminal street gang. It's not the kind y'all are used to. If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago. But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices that committed crimes on behalf of and in furtherance of Rock Crew itself. That particular organization aligned itself under an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. They adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Cleveland. Some of you may have indicated during voir dire you've heard or are familiar with the Cleveland Avenue area. Maybe you've even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will also show that sometime in 2012 or thereabouts, an internal rift or divide occurred among the members of Rock Crew. Now, the defendant, Jeffrey Williams, seated back there yawning right now, he was an original member of Rock Crew. And the kind of crimes that Rock Crew did consisted of smashing grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated in fact, who used common identifiers, common names, common colors, common symbols to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffrey Williams as its head. You'll hear from witnesses, both law enforcement and lay witnesses.
This is like a witch hunt, in my opinion. I mean, this is ridiculous. It's fucking absolutely ridiculous. I don't know, to take their lyrics out of their songs and out of their music and try to charge them with the crimes. It's I'm sure they're not innocent with certain things. Don't get me wrong. I'm not saying that. For sure. Don't take it that way.
Who personally experienced and who personally witnessed the activities, the crimes that were committed. You'll hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully. But the court has given you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checks all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotics sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting, and under Parker versus the state at 277.
Why don't we take that up and
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
yes, Your Honor.
Just rephrase it. Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove or certain innocence, they're presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay? All right.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with the gang itself. Through their actions, they have displayed an unspoken agreement to participate in that gang through a pattern of illegal activities. And again, the head of this gang is seated in this courtroom too. The last paragraph of that poem that I read, spoke to you earlier, goes as follows. Because of his age and his cunning, because of his right.
This is argument. This is not,
What's your objection, Mr. Harvey?
that it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, Your Honor.
All right.
The evidence will show that these defendants, that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Now, they didn't call him directly because he knew, and they knew, that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King's Line, as they call him. You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. You'll hear evidence that when one of the associates or members of YSL did something to what Jeffrey Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood Family. You'll hear experts come in here and tell you more about how the Inglewood family Bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies, 2015. Gunned down, openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment. You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift young Limelight had with other people in the community. So what are they accused of, and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago. He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state is proving to you over the next several weeks include conspiracy to violate the Racketeer Influence and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say RICO. There's no substantive allegation of RICO violations here. And by that, I mean, there's a difference. Here, the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement, to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that it's sort of like if 2 people said, okay, you know what, we're gonna go toilet paper our dean of admissions house. And they sat there thinking and talking about it, and someone overheard them and reported them to the police. And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go and do this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those 2 people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine. Does this action show that they're agreeing to participate in this organization, this enterprise, through racketeering activity? You'll see evidence, as I stated, of not just drug sales, houses, drug houses, whole houses out of which drug sales were conducted, where they held long-arm guns by the door, where they stood ready to act on command if either one of their number calls. Who's on trial before you today is Rodelius Ryan, Lamarcus Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stilwell, Diamante Kendrick. And their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor. You have an objection?
Yes, sir.
Basis.
A motion.
All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters to your deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right? Remember the court's admonitions, ladies and gentlemen. All right, please be seated. Our jury has left us. All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they have. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put up and I asked for it to be marked as an exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent a co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to the Honorable Court's attention? 1. And 2, how do we just violate court orders? So yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it is next court exhibit in order of the state's presentation anyway. So, all right. So that'll be court 1 for purposes of the trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, man.
Excuse me. I've never said this ever. That's it.
So what's your objection based upon, Mr. Steele?
Objection based on, I argued this before this honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
You brought him up to this honorable court, outside the presence of everybody. We're an opening statement. I am lied to. I am saying that I am lied to. I don't know if anyone else got that exhibit. I did not get that exhibit. And I'm seeing everyone say shaking no. And now it goes to answer the court's order. We are bound, duty bound to follow this honorable court's order.
I join in the objection on behalf of Mr. Steele.
Let me see the.
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that, I ruled upon that last week. I did. We were not, I would take it as it came in this case. And if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
And Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction And a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have
All right.
the slide.
Pull up,
I
now
have it now. I'm
court
about to
action,
share.
court one for purposes of the motion, for mistrial. All right. Yeah, on slide 11 of 65, that I see where you have that at the bottom, represented by Brian Steele. So we can leave that for the time being. Leave it for the time being because it is what was it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So,
Your Honor, I'm supposed to ask for a reoccurrence for my mistrial for the next process goes on. I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
you've made your motion for mistrial and the basis, and I have marked I'm going to mark the whole state's presentation as is as court one for the purpose of your motion, and it will go in as stated.
I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today that Mr. Williams is contacting through parties that they don't know to pay for other people's lawyers. So I think that couples with that exhibit. And number two, I'd like the court to now order prosecution to give me and anyone else who wants to see it. I need to see, respectfully, what you ordered last week, all of the displays of the state of Georgia that they have not given to us. So that's
What do you mean by what displays are you talking about, Mr. Steele?
I never saw that. I never saw the wolf. I never saw the indictment. You ordered I gave all my displays. I gave everything to say I got from the state.
Are you talking about using for opening statements, sir?
Of course.
Okay.
Should have been done.
All right, Ms. Lowe. Wait.
Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at
I'm
trial.
going to deny that portion, but to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and also subject to foundation, just like this. So I assume that what you told our jurors is what you expect the evidence to show. Yes.
Yes,
All right.
definitely.
So I'm going to overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name on
I got
here.
that, but he's talking about, is there anything else you're going to use in opening you haven't shown to defense counsel?
I
He's
don't
telling
mind
us,
sharing.
well, I said that. I told you to do that a week ago.
Your Honor,
Because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
Can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, we have a few.
Your Honor, Jay Apt on behalf of Mr. Kendrick, have 5 or 10 minutes to review whatever Ms. Love is going to send us.
You can take a comfort break and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch, okay?
Thank you, Your Honor.
Who's talking?
That's Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwell.
He's fucking pissed, boy. Yeah, this judge is the shit, but he's mad as fuck. Did you hear that? Woo! Spicy.
We've been operating pretrial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial. And if Your Honor,
I'll apply the Harvey rule unless you tell me otherwise. Okay?
and that will apply throughout trial.
Yes.
Okay, thank you.
Unless you tell me otherwise. Okay? All right.
Thank you.
All right, we're going to be in recess about 10 minutes. All right?
Your Honor, what I'm going to do before stating is I'm going to actually do a search for the first 4 letters of Mr. Steele's name to make sure that I didn't need anything else in there. So before I do that, I'm going to send that. I'll make that search.
Yeah, he's pissed. He ain't fucking having that shit. Like, she should have been fucking prepared. And like he said, you gave me everything except for that. Why the fuck didn't you give me that?
And
Already ruled on that, saying that
We concluded our sharing exercise. I told you all to go ahead and talk with each other through when we broke.
I did share, Your Honor. If I may, Your Honor.
Yes, ma'am.
Regarding the court's earlier concern brought to the court's attention by Mr. Williams, Ms. Hilton chaired me, but was sitting on the bench. But as it relates to Cordelius Ryan's post after the murder of Shamel Drinks, that was provided from day one in discovery, Your Honor. And it is not a crime that he is alleged to have committed. We may have put that on a list, including things, but Your Honor, that is not an intrinsic act in the sense of it being a crime or criminal act. And it is what the evidence is going to show happened. What I have in the PowerPoint, I can show the court if you like. I sent that to the defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Shamel Drinks was, I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I said was that on the day that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I endeavored to say to the jury, that the evidence will show is just that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that the court, I believe, will hear from detectives and evidence. These are things that the court has said jurors and the courts should look to determine whether something was done in furtherance of a gang. And so I would ask the court, I can take it out of the court and instruct it. I would ask that the court allow you to make reference to it. And thank you, Your Honor, for your time.
Mr. Williams. Oh, sit down, Mr. Allen. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
that the court already ruled on, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court.
Oh, hell, here we go. Get ready, because this one right here starts fucking talking about anime. Oh, fuck. Get ready. Listen to this.
Court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily necessarily be intrinsic. It might be for another purpose. It's what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed as the court. You all could, we've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, that if I believe that's what the evidence will show. Okay?
They put it in their motion as,
Say again, ma'am, I'm sorry.
they put it in their motion as intrinsic evidence though. So they shouldn't have put it in their motion if they were going to.
Yes, ma'am, I would probably agree with you, but did I ever rule on that issue?
You said that you would do it later as it came.
Okay, well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides. But do you have any other basis for the ruling? I mean, for my ruling, madam, any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, okay? And give me the full breadth of, I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old Shimel Drinks. And my client has nothing to do with that.
That was another area I'm correcting.
But I didn't get that.
Ms. Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay, all right. Now, Ms. App, what is it you want to tell me?
I'm so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So, Ms.
What's your objection specifically, sir?
Attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsel and staff.
They're getting pissed. They're really getting fucking pissed. And I don't fucking blame them. I would be getting pissed too. I would be about fucking done. Anyways, when they're done with this, we'll take a quick little side step here, and I'll show y'all real quick where Penguin came up and did this real fast. He put it up.
And Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share it with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
Yes, ma'am, and I'll go on to the next person.
Thank you.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed ongoing. And I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I said to them, if they can, actually, I sent them to them. So there are some, I have only about.
Your Honor, they're done over.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Abt.
So all of these slides that involve Christian Eppinger, I sent to them. And other than the slides involving Christian Eppinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle with the placards of showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to as being admissible at trial. And I believe that, I'm not certain if Mr. Abt thinks that we only served 4. I don't know if he had trouble opening it up, but we served, I think, all of them, if not the great majority of them, because I don't have that many. I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I'll share it. I did not with the court as well, but these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted. And then I have pictures of Christian Eppinger, all of which were provided, and that's the extent of it. The majority of the slides have my words, my work product on them.
All right, Mr. App, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument. But if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying to the court. But if it's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. If there's no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of her opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what the court instructed. And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today. Whether they're evidence or whether...
Look, he ain't fucking around. He sat down and stood right back up, and I got more to fucking say.
their text is part of her opening.
All right, Mr. Matthews?
Yes, Your Honor. Good morning to the court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020, in terms of that quote from the text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation. So number one. Number two, the quote in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquez Huey. And then we go to slide 16. Slide 16 is an overt act that is alleged in the indictment as Overt Act 123. In the state's opening presentation, the date they have is October 1, 2020, but in the indictment, that particular overt act is November 16, 2020. So that's the third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury judge. So I would ask the state correct that, remove it, or correct it.
Anybody else? Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 47, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang, even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week. But we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet. And I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you would look at also I'm looking at now for 48, 49, 53, 54, 55. That's your prerogative. That's your zone. That's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court, as a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, judge's law.
You can tell they're tired of her shit.
In terms of what slides are you talking about, Mr. Steele, again?
I have 48, 49, 53, 54, 55,
So 49, 48 through 55?
excluding, so 48, 49, and then skipping to 53, 54, and 55.
48 and 49. You want me to share via Zoom the slides that Mr. Steele?
I would, yes, please.
Thank you. And you said, Mr. Steele, you said 45?
Just share the presentation, please.
Okay, so Your Honor, I'm showing on the screen slide 48, which is the last thing that the court.
Take notes.
Yes, Your Honor.
All right.
And
49.
that was directly from what the court just said.
All right. 50.
50,
It's not 50, sir, 53.
53. Okay, let's get down to 53. And 53 is what I expect the evidence is going to show. So I want to, in speaking with jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid, some of them are embarrassed, some of them are intimidated, some of them don't remember, some of them don't want to remember. That's simply what the evidence will show. And Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is, as the court has already instructed, which is just to use your common sense because you all decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way infringing on or entering into a lane that does not belong to the state. We are entitled and allowed to show and to state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are embarrassed. So I can take out.
Well, that's different. You might want to just redo it.
I can do that.
Any further objections, folks?
Yes, Your Honor. I went over to the state's table, Carson Matthews and Beth Jew. I went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Is that correct, State?
All right, here's what I'm going to do. Folks, this is exactly why I told you I wanted you to, and let me go ahead and just say this, Ms. Love, I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play or the slides that you have that otherwise have not been shown, you need to show them to defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone. They need to get and the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reason I told you all to do that. So,
Your Honor, as far as any typographical errors.
I'm not worried about that. But I'm not worried about that. But the errors that Mr. Apt, Mr. Matthews, and Mr. Shaw have made are errors, and Ms. D. Williams need to be corrected. Okay?
Yes, Your Honor, I will, of course, correct.
But everyone else needs to see it so they can be comfortable and make sure that you represented something that what you expect the evidence to show to be correct. Okay?
Thank you, Judge. Will do. Your Honor, I also wanted to point out to the court that even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
But that's not the point. I'm going to tell them that. And I told them that already. But that's not the point. The point is so that we can have a smooth and orderly presentation of evidence. Okay? So, all right. Stephanie, Sergeant Ingram, can we go ahead and call for our jurors, please? You can go ahead and take up that during the recess. Okay?
Yes, sir.
All right. Yes. All right, send you lunch. How about that? But the bad news is I'm not paying for it. So hopefully you all brought something or have made suitable plans consistent with the court's earlier suggestions to you. So what I'll do is at this point in time it's about 12:20, almost 12:25.
PowerPoint in real time, so.
All right. They done left for lunch and came back already. Here we go.
They can see any change or anything that was made. We actually took out most of the photographs that we initially included, particularly most of Christian Evanger. So I have not heard from anyone on the defense team that there was any other objections. We added back in Rodelius Ryan's party opponent omission on the date of the murder of Jamari Holmes. And we would like to, but have not, add the third homicide victim's photograph in, and that was it. So I have not heard anything from anyone regarding any of the changes.
Okay. Do I have any further objection? Are there any further objections to the state's PowerPoint that you all, or changes that you all individually have objections as to going forward?
I would propose. Go ahead, Mr. Steele. Your Honor, I understand the court's ruling, previous ruling, just renew my objection that I think because the state didn't turn these over, these over, they should be excluded.
Mr. Steele?
Yes, Your Honor, I was unaware that there were changes. I apologize. No one told me that and getting an email to that or text.
I told you all to do that during lunch. That was my last conversation with you all before I went ahead and broke for lunch.
That's what I've been doing. I'm waiting. I've been right here. In the hallway and in that other room gate. So I understand that the state updated something, and not realize that that's what they were doing.
Yeah, we would be making those corrections.
You know, you all don't listen to the court, and it's going to get you all in a lot of hot water. You need to listen to me when I tell you something, and don't rely upon your own understanding. If you have clarification, ask me at that point in time. I'm more than happy to do that for you. But that's not what I told you all to do during the break. These jurors are waiting back there. We are dallying out here. So, you didn't follow my instructions, Mr. Steele. I mean, that's what I asked you all to do. I asked you all to share each. We're already behind to begin with. So, any further objections?
Yes, Your Honor, I didn't know that they were changing.
Yes, Ms. D. Williams.
And on slide 10 and 13, they misquoted the Instagram post.
They misquoted it?
Yes, they did. It says, I bet YSL make the news tonight. That's not what the Instagram post says.
Your Honor, we actually copied the Instagram post into slides 10 and 13.
And it does not say tonight.
I'm sorry, okay. I will take out the word tonight. She's right.
Anything further? Mr. Starr, did you rise to?
Well, I'm just seeking
I, on behalf of, I think, everyone in this back row, we're seeking clarification. Is the state saying that the same link that they sent earlier before the changes will now show an updated version?
In fact, it does. It has on every other person's computer who has this PowerPoint. And at the appropriate time, we would, Mr. Sharp shared his PowerPoint. We were able to see it, and the state has objections to the argument slide in Mr. Sharp's PowerPoint that we would like to stress before.
Could you repeat that, Ms. Love, again?
Yes, Judge.
Mr. Harvey can't hear back there.
So the state shared its PowerPoint with all parties, including other members of the state's team and the other members of the state's team that have looked at the PowerPoint. They were able to see in real time the changes that are being made, as are anyone with the link that I shared with the defense earlier. Additionally, Mr. Sharp, over the lunch break, shared for the first time his PowerPoint and has included slides to which the state objects and has responded and told the court and Mr. Sharp that we object to. But I just wanted to make the court aware before we were in front of a jury again, as this, I think, is the appropriate time to do so. But the changes that the state made were available and published to everyone on counsel for the defense team.
All right.
Okay. I think the confusion, Your Honor, I understand what the state's saying now. The confusion is no one on the defense team we were waiting on a new email with a new version of the power.
That's not what I told you all to do. I was pretty clear. I said, y'all over lunch, just take a look at the state's PowerPoint, make sure you have no further objections. I didn't tell you to go email it to you. I just told you to look at it. I don't care how you did it, but that would be the thing I would probably have gone through and said, hey, let me see slide 1, 2, 3, 4, 5, 6, 7, 8, 9, whatever else.
Okay. We were waiting. We had voiced some concerns already, and we were waiting on the new version. And I'm just explaining, Your Honor. I don't think anyone was aware that it was being edited on that old link. I think people were waiting on a new version of the PowerPoint.
Okay. Here's what I'm going to do. I'm excluding the PowerPoints. Y'all just gonna have to make this thing up the whole way. Yeah, just make an opening statement. No PowerPoints. Let's bring our jury in. No PowerPoints because you all did not do, hold on, I'm starting to go. You didn't do what I told you to do. And that was to exchange PowerPoints. We have wasted almost 2 hours trying to get this stuff done. And my orders to you are not aspirational. They're given for a reason. And when you don't follow them, then I have a way to remedy that. So the remedy is nobody uses no PowerPoints, okay?
If I could address the board, Archie Matthews from Mr. Hughes. In terms of what we have done here on our team, we have provided our opening statement to the state of Georgia as well as to every other person on the defense side. We have received from the state of Georgia an updated, came to my email from the state of Georgia with the changes as it relates to Mr. Hughes. I have it. I will be hamstrung, Your Honor, if I am not able to use my opening statement because I prepared my case with my opening statement. I have not committed every single slide to memory, Judge. I'm depending on my opening statement to present to the court, to the jury, Judge. So I'm asking the court to reconsider its position as it relates to Mr. Hughes. Respect.
All right. Mr. Steele?
I sent our entire PowerPoint to the state of Georgia last Tuesday.
Which the court has already. I do acknowledge that.
I did everything the court demanded.
All right.
So I'd like to use mine.
Okay, all right.
Your Honor, to be clear, on behalf of Mr. Stillwell, I sent over all the.
When did you send it?
On Friday, I sent all the photos of the exhibits that I plan to use or the monsters I plan to use, save for one which I did not have physical custody of, which is a Fulton County jail uniform, which I took a picture of. And I have it with me right now. But I did not have that on Friday when I sent that over. I did not have custody of that object. Regarding the PowerPoints, when the state finally handed over their PowerPoint and said that they didn't realize they were supposed to hand over the entire PowerPoint, but which they didn't do that either, by the way. I did. I sent them out of an abundance of caution my entire PowerPoint. So.
And Your Honor, I don't object to, generally speaking, the PowerPoints that have been shown. What the state did do was exactly as the court directed during the lunch break, as Mr. Matthews was able to see, we provided to each member of the defense team every change that we made. And respectfully, Your Honor, we would also request that the court allow the state to continue in the path that it has gone. We have complied with the court's directive.
No, you didn't actually. The court's directive was you were supposed to turn this over way beforehand, because then we could have corrected these issues and not spent 2 hours on doing this. I'm deeply disappointed in, because this is exactly what I told you all was going to happen, was that we are going to end up dealing with a lot of objections. And I mean, I don't mind dealing with the objections, but I got to have time to do so. So that's why I told you I had to start having this discussion with you about a week, almost 2 weeks ago. Mr. Steele brought that up, saying, hey, go ahead and turn over your PowerPoints so that we can go ahead and, if the court mentioned, have as smooth as an opening statement as we possibly could. That obviously, very few people adhered to the court's instructions, and we find my words to you a self-fulfilling prophecy, meaning that we are still dealing with this particular issue, and our jurors are waiting on us. So,
Now, we have, as well, as I stated, we provided the photographs we intended to use.
The judge is fucking pissed, Jack. What the fuck? You guys are in here wasting our time, wasting the jurors' time. What the fuck is going on here? Should have had this shit done. What the fuck is up? yeah, this shit's messy as hell. This trial is fucking messy, and it gets worse. So this definitely is not this definitely is not the end of it.
To provide them.
Friday before 5, Your Honor. The language that is in the PowerPoint are the words, our opening, our things. They all have that. Everyone has that. I don't believe that there is a general objection to that. Every objected to portion of the PowerPoint that the state has, Your Honor, has been modified to address those objections. And we just ask the court to allow the parties to proceed as we have been proceeding with respect to presentment of opening statements. Additionally, Your Honor, I am not objecting on the basis of anyone having given the state the PowerPoints today. I'm not objecting as it relates to when anyone gave us the PowerPoints. I only objected to these photographs that were provided to us just a few moments ago on the basis of that they were argumentative. And I want to bring that to the court's attention. If the court decides that they say again, even though they're argumentative, the state has, we can get past that quite easily. We would just ask that the court allow the parties to proceed as we have.
Are you referring to I'm in possession of 2 emails with photographs. I'll mark it as the next court exhibit in order. One of them is, it has the subject of state objects to arguments contained in Shannon Stillwell slides below. And I have a couple of, it has like 3 slides.
Yes.
I'm going to mark that as the next court exhibit in order.
Yes.
Mr. Sharp, why don't you believe this is objectionable? It would seem to me it's got pictures of a couple of folks here in our facility and a picture that's probably more prejudicial than probative. And it has somebody that's purports to be an inmate. So why wouldn't that be?
I don't think, Your Honor.
Yes.
I don't believe.
I'm not seeing the email. I see an email saying the state objects to use of these photographs during opening.
It's got your 4 slides, state's key witnesses, Nicholas Robinson, and then Nicholas Robin, a.k.a. Spencer Wright. Those are 3 that I'm looking at.
It's not showing that in my email. I'm seeing 2 pictures of jail.
I got that one too, which I'll mark as the next court exhibit in order. And that's the 2 pictures that you referred to. And it has the state subject matter is the state objects to the use of these photographs during opening.
Could I see what we're talking about? Because I don't have it on my email.
Sure.
Let's see.
Christina, can you mark these in the next court exhibits and then show them to Mr. Sharp? Counselors, you can approach and take a look at it.
And Your Honor, the court will
Thanks, Doug. one did you mark it as so we can?
It's marked Exhibit 2.
Courts two, or
Yes.
next court's exhibit in order, okay, all right.
And I wasn't on that email, and that's fine. I just wanted you to, that's why I hadn't received it. So this case is going to involve,
Objectionable.
well, I'm allowed to preview the evidence that I believe that will come out. I not only believe, but I know that several of the witnesses in the case, which I'm going to discuss in opening, became involved in this case once they were in the Fulton County Jail. They were jail inmates, okay? Now, I'm allowed to preview the case in that way to the extent if the state has a particular argument or objection to one of the photos, then we can talk about that, but, okay.
Court does.
Well, I can alter my,
I mean,
so what is it you want me to alter, Your Honor, to avoid?
the picture, and if the state doesn't have any objection to the, you saying anything about any other witnesses in custody, then, that's certainly within their purview.
Well, the case law, as I understand it, allows us to preview the case and let the jurors know in advance that witnesses were in custody at the time they made statements. That is completely appropriate as under the law, as I understand it. Now, if there's a problem with the pictures, as I said, Your Honor, I will remedy that. That's not a big deal.
I think, well, I would ask that you take the pictures out.
Okay.
All this back and forth bullshit over some pictures. Like,
Okay.
That's fine.
What about the argument in the pictures seem to be, and that would solve that issue. So what about the other issue about the slides?
Well, they also said this Nicholas Robinson one. I'm not sure what their objection is. I will be letting the jury know, which will come out in evidence, that a man who claimed to be named Nicholas Robinson was arrested on October 19th, 2015. He's an important witness in this case. They will know, the evidence will show that he was interviewed by Detective Thorpe, and he gave his vantage point of where he was, and he told a story which involved the guilt of 5 people that are listed on this slide. And that evidence will come out at trial, and I don't see anything objectionable about this at all.
All right, Ms. Love.
Judge, I don't object to Mr. Sharp telling the jury the words that he has shared with the court. What I object to is the imagery that is depicted in the.
You mean the person that's in a uniform as well as the purported condition of the jail in that lower one?
Well, correct. That's a separate slide. That's a separate slide. These are 2 separate slides. I just want to make clear. These are 2 separate slides. So I'm saying that I'll take out the pictures.
And also the giving of the false information. So the problem that I have, the only problems that I have with the language in the other slide is that part of that information is improper impeachment that Mr. Sharp would not be able to introduce at trial.
Except that,
and I don't have any problem with Mr. Sharp telling the jury that the evidence will show something about Nicholas Robinson, but he has listed all of the arrests for Mr. Wright, Mr. Spencer Wright.
who is Nicholas Robinson, Your Honor, just so the record's clear. Your Honor, as Your Honor knows, we're allowed to impeach with prior convictions.
They gotta be called first, right?
But we are also able to impeach with bias. And the fact that this gentleman was arrested, Your Honor, that's the central crux of this case, and it's something that the jurors need to be made alert and to look out for as this case is presented. The bottom line is Mr. Wright, who identified himself as Mr. Robinson, was arrested on felony charges and probation violations on 10/19/15. And then he reached out to APD and said he wanted to give information. And then he met with Detective Thorpe. Nothing I'm saying is incorrect. It's all accurate. It all would go to his bias and motive and reasons for coming forward. And
So you're saying this is what he was arrested on the 15th?
right,
On 10/19/15?
correct.
Okay, all right. Okay.
And quite honestly, off the top of my head, I don't know how those cases were resolved, but they were biased at the time that he made those
Are
statements.
you saying that because the evidence will show that he then gave information against your client
Yes,
or involving your client?
yes.
And Judge, I don't have a problem with him saying that Mr. Wright was in jail. I don't have a problem with him saying he had open charges. It is the listing of the specific ones that
What?
we objected to.
I don't know why that's
Because they're
objection.
not convictions and that is not the proper method.
Yeah,
to
I would
show
agree with that. So you can talk about, unless you get them in a proper format, yes, you can talk about if you have criminal charges, that would be appropriate. What happened as a result of that, but I think the longer listing of that, because you said, you don't know what happened to him, so.
But the reason I'm saying that is because I think it's irrelevant because this is really about bias.
It's not proper though. It's not proper format. Bias is fine. You can talk about the.
But he had the bias because he was facing these. Certainly, if someone's arrested for murder,
You just can't mention the individual charges themselves unless they're in the proper format.
I
okay?
understand. My only point would be, Your Honor, certainly if someone was charged for jaywalking, arrested for jaywalking, and someone else was arrested for murder, the bias, the level of bias would be different. So,
Okay, but what does that have to do with them not being in proper format though?
because the jury is allowed to understand specifically what bias the person has, not that they're just in jail, but what they are facing. I'm not
If you can get it in the proper format, then you can tell them about that. Do you know what happened in these trigger charges?
Well, but they
Is
had been
Nicholas
resolved
Robinson going to testify?
at the time that they,
Answer my question. Is Nicholas Robinson
I was over here talking away and didn't realize I was muted and it was off. I'm sorry, y'all.
going to testify?
if the state doesn't call him, I will.
Okay, well then, at that point, then it might be appropriate for you to get into that specifics. But unless you're going to package that up, and certainly that's not, you can decide that. You don't have any responsibility to present anything on behalf of your client. But in order for you to delve into it, it has to be in a proper format. I would agree with the state with that. I was just saying that objection. But you can talk about arrests. You can talk about pending charges. You can talk about that, you'll present evidence sufficient to show that he's got an axe to grind. He's got bias.
So you're, just for clarification, because I want to get this right, we're saying your instruction is that I can say that he was arrested and he had pending charges, but I just can't say what those charges are.
Until and unless they become you get them in the proper format, or you have a witness you can lay a foundation for those. Okay?
Okay, and the third thing, Your Honor, is I have a Fulton County jumpsuit. This is the same uniform, not actually the same one, but is the same make and model that a number of the state's witnesses were wearing when they inserted themselves into this case. I wish to preview to the jury and say the evidence will show that these individuals were in Fulton County custody wearing this jumpsuit, at this shirt at the time that they gave statements. That's previewing the case. There's nothing objectionable about it. I'm not going to put it on. I'm not going to jump around the table. I'm not going to do anything with it. I'm just going to show them and say this is what they're wearing.
All right, Madam.
Judge, I think that is appropriate for argument, but saying and making certain Mr. Sharp can tell the jury that the evidence will show they were in custody, all that, but that I would argue would be more appropriate for a closing argument. And that is argumentative.
I believe it is appropriate for a closing argument, but I think it's also appropriate for an opening argument. And I'm allowed to use demonstratives to try to get my point across to the jurors in a way that will stick in their mind, because we all know that they're going to be listening to 15 hours of probably, or 10 hours of opening statements and 9 whatever of testimony in this case.
All right, I'm going to sustain that particular objection and also remove the, ask you to remove that picture of what purports to be as, I think it's a cell or something like that. So remove.
Yes.
So yes.
Remove the pictures.
And lose that for the time being. Sure. For the time.
Okay, and take off the specifics.
Take off specifics. Okay.
All right. Thank you, Your Honor.
All right.
Your Honor, hold on.
Oh.
Mr. App, have your client put on his shoes. All right. Anything else? Anybody else?
Your Honor, there was not anything with respect to any of the defense.
Good God, this is what the hell's going on here? Lord, come on with it.
But there was a matter that probably is best addressed with a member of defense counsel at the bench briefly. It is a short matter.
Okay.
All defense counsel?
Either one, it doesn't matter. It's not. So,
All right. Put your headsets on, please. They have to also hold it. Can you hear me? Okay, all right. Okay. Yes, Mr. Steele, what is it?
On the PowerPoint, I'd like you to grab the newest one, and I got the last one. Number 19 is argumentative. Number 41 through 47.
Lunch. All right, good. Okay, ladies and gentlemen, before we go ahead and continue with the state's opening statement, I need to kind of just advise you of just something that was said to you earlier, okay? So with your patience, all right, I believe the state counsel earlier referred to some representation of the parties, and I just want to remind you two things. Remember that opening statements are not evidence, and that what the attorneys say is not evidence. And with that, Ms. Love, you can continue, okay?
thank you, Your Honor.
All right.
And thank you, ladies and gentlemen of the jury. I like the court. I hope you all had a great lunch and can stay awake with me for just a few moments more. So where we left off, the crimes that the defendants are accused of committing in this case. You're going to have the indictment with you. It's going to go back. A listing of them includes the following: conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, murder, armed robbery, aggravated assault, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, and death by receiving stolen firearms.
And those are all felonies right off the top.
Among other things. This list is not exhaustive. You will have again with you the indictment, and you are to consider as the state commits burden. So breaking it down, the evidence is going to show that the defendants, when we say conspiracy, it's nothing elaborate. It's a legal term, which simply means the evidence is going to show that the defendants had an agreement. It will not be a written contract presented to you. There will not be a letter signed in blood by any of the defendants. But what you will see evidence of is the defendants' actions, their presence, their companionship, their conduct, before, during, and after a long list of crimes. And what you will see is that the defendants weren't always convicted of these crimes. Sometimes the state no-crossed or dismissed charges. Sometimes the police never brought formal charges. But what the evidence shows is that the defendants did commit those crimes. And when we're talking about a conspiracy, an agreement, just an agreement, unspoken agreement, we're gonna participate in YSL through a pattern of racketeering activity. That's another large word that is used in the legal community, but regular folks, myself included, just don't generally tend to use it. Racketeering activity is nothing more than certain crimes, the crimes that are listed out in the indictment. You will see that, and the court will instruct you, I expect, that those crimes constitute racketeering activity. And as I stated before you all broke for lunch, a conspiracy requires just one overt act. So you will see evidence of several overt acts. Several acts that were done by these defendants and by unnamed and unindicted people as well, to further the interests, to further the goal of the conspiracy that the defendants participated in. You will see overt acts meant to establish YSL's dominance and control. You will see overt acts meant to gain illegally access to money and wealth and property that did not belong to YSL. You will see overt acts, steps taken on the part of various individuals to act to protect the group as a whole. Steps that have nothing to do with a recording label. Steps that have nothing to do with an A&R executive. You will see steps that were taken solely for the purpose of illegally gaining goods for and on the behalf of YSL and its members. You will see steps taken by each of the defendants to protect the members of YSL, to establish the dominance and control of YSL. Nothing in what I expect court will tell you, nothing in the evidence will suggest that any of the defendants had to be convicted of all of the overt acts in order for you to see that they actually had an agreement. The acts don't even have to be crimes, but they are. And that is how the state expects you will know that these defendants They wanted to participate in this enterprise. They wanted to participate in this organization through these illegal acts. They wanted to obtain ill-gotten goods that they did not have a right to have through robbery, through stealing, through drug sales, and the like. So we'll start off by looking at the defendants. 6 of them are at the table, and 6 of them are here for you all to decide as the state proven its case. Rodelius Ryan. Rodelius Ryan is one of those people whose youth and life was swallowed up in the crater created by YSL in the Cleveland Avenue community. The evidence is going to show that in 2019, Rodelius Ryan was 15 years old. And that in February of 2019, Rodelius Ryan used female acquaintances to lure Jamari Holmes to a particular address here in Fulton County. The female acquaintance lured Jamari Holmes to that address, telling Jamari that he would get sex and weed once they got there. Instead, when they got to the address, the female gets out of the car and the defendant, Rodelius Ryan, and his accomplice, Damone Blaylock, also a YSL member and associate, they then came out to the car with guns. The evidence will show that Rodelius Ryan and Damone Blaylock then fired those guns into the car where Jamari Holmes, not even 20 years old, was seated and hit him in the back of the head with a bullet that took his life. Jamari Holmes is another one of those young lives, the evidence will show, that was swallowed up by the crater that YSL created and left in the middle of the Cleveland Avenue community in Fulton County. 12 hours after shooting and killing 19-year-old Jamari Holmes, the evidence will show that Rodelius Ryan didn't say, I bet I make the news. Rodelius Ryan posts on his Instagram account, I bet YSL makes the news. The evidence will show that in posting about YSL as it related to his flagrant, overt act of extreme violence, Rodelius Ryan was agreeing to and attempting to participate in YSL through this illegal activity. He was promoting the gang. He was showing their dominance. He was showing their power, and he was showing their control. Rodney Uten was also in the car with Jamari Holmes. That's another young life. He wasn't taken, he survived. But he was forever changed by the acts of YSL, conducting and committing violence on behalf of the entire organization. And in case it hasn't been lost on you, Rodelius Ryan's Instagram handle that he used, Slime Business Ride. Because as the evidence will show, slime is spoken and used to signify doing someone dirt. And Rodelius Ryan is proudly proclaiming his association with YSL as he talks about and as he promotes the gang itself. Rodelius Ryan's accomplice, another YSL member who's not here today, but who is a co-conspirator. What did he post after they killed Jamari Holmes? The evidence will show that Damone Blaylock didn't say friendship over females. He didn't say Blaylock over buddies. He said slime over sluts. Slime over sluts while posting a YSL gang hand sign with the caption slime over sluts, a green heart emoji, and a green snake emoji, which I expect the evidence will show are the common identifiers associated with YSL. They're the identifiers that they use to announce and project themselves to the rest of the world. And then, on February the 25th, 2019, Rodelius Ryan made another posting where he's flashing cash money on his Instagram page with the caption, "Fuck YFN." YFN being a rival criminal street gang. The evidence will show that none of this was a part of what anybody has to do to be a part of a record label. The evidence will show that these acts were done in furtherance of and to promote the goals of the enterprise, the criminal street gang that is Young Slime Life. And what did the paper say? 15-year-old, they called Jamari Holmes a known gang member, but the evidence is going to show that that's not who he was to the people who cared about him most. Jamari Holmes was Jamari Holmes. He was a baby, a child, found shot to death inside a stolen car, police said. Jamari Holmes was just the latest victim of YSL's quest to maintain and retain dominance and control of the Cleveland Avenue community. Again, Rodelius Ryan didn't post, "I bet I make the news." He said, "I bet YSL makes the news." Marquavius Huey, he's also on trial for you to determine whether the state has met its burden of proving he committed the acts that are listed in this indictment. Marquavius Huey showed his agreement to participate in the activities of YSL through a pattern of racketeering activity. He showed his willingness to commit acts on behalf of the gang through his actions. The stolen handgun he had, that was the property of Jeremy Smith. Because as you will see throughout this trial, stolen handguns will become a reoccurring theme. There's no need for a legitimate organization not comprised of people committing crimes on behalf of the organization to have all these stolen handguns. Everybody has a right to have a gun, so if you're legitimate, just go get one. But the evidence will show that in this case, YSL members stolen handguns every time you turn around. And not just stolen handguns. The evidence will show that most recently in May of 2022, where some of these defendants were found at the home of Jeffrey Williams, their leader, it wasn't just stolen handguns that YSL dealt with. It was machine guns. You'll hear evidence that at the home of Jeffrey Williams, in addition to the pharmacy full of drugs, that there is a gun with a switch that allows, with one trigger pull, 10 times more bullets to come out at a time than if you just had a regular gun. There will be no evidence to show any need for that in legitimate, ordinary, record deal making business. The evidence will show that the existence of those dangerous weapons like the machine gun, the stolen firearms, those things are all evidence of these defendants' conspiracy. Those things are all evidence of the existence of the enterprise known as YSL, whose goal it is to maintain and retain dominance, control, and ill-gotten gains. Marquavius Huey, on April the 26th of 2019, further showed by his actions, showed his agreement to participate in YSL through a pattern of racketeering activity, illegal activity. When he took the property, jewelry, money, and a debit card of Dewan Maynard by use of a firearm. Dewan Maynard, another life affected by this crater created by YSL in the middle of the Cleveland Avenue community. Marquavius Huey showed his agreement to participate in this enterprise when he struck Maynard in the face with that gun that he used to take Mr. Maynard's belongings. Marquavius Huey hijacked on October 1st of 2020 a Buick LaCrosse from yet another victim of YSL's violence, Gary Holloman, by force in violation of the law. Mr. Holloman has since passed away, not from that incident. So he won't be here to tell you what he was feeling and how he was able to tell the police who it was that committed this armed robbery. What you will hear evidence of is the extraction from Marquavius Huey's phone, where he's planning the armed robbery, where he set up with Mr. Holloman a ruse so that he could have the opportunity, along with another uncharged, unfound individual, so he could have the opportunity to put a gun in Mr. Holloman's face and rob him. What Marquavius Huey did was kind of slimy, the evidence will show. He told Mr. Holloman, hey, your nephew in the Fulton County Jail, Tinquarius Mender, he needs some money on his books. So he wants me to meet with you to get money to put on his books. So Mr. Holloman, because he loves his nephew, and any friend of his nephew coming to him that way is legit, right? The evidence will show that Mr. Holloman arrives intending to meet the person so that he could give to them the money for his nephew. And to his shock and horror, he's met with the butt of a gun, two people, one with a long gun, one with a handgun, demanding his money. And that day, as the evidence will show, Mr. Holloman wasn't the only person affected by the violence perpetuated every day by YSL. Delmisha Coppage, she just happened to be on scene. She just happened to be right there conversing with and talking to Mr. Holloman when the defendant and his accomplice came up, held him at gunpoint, and demanded their belongings. You'll hear how they directed Delmisha Coppage to just sit on the ground, just give me your stuff. You'll hear how they robbed Delmisha Coppage at gunpoint. The evidence is going to show Mr. Huey's tight relationship with their leader, Jeffrey Williams. The evidence will show that Mr. Huey, on various occasions, checked in with, reached out to Mr. Williams to see, hey, I got this stolen item. You want first dibs on it? Marquavius Huey's actions that betrayed his agreement to participate in the conspiracy didn't stop with Gary Holloman and Domisha Coppage. The evidence will show that in November of 2020, he made terroristic threats towards Justice Woodard after Woodard told Mr. Huey she'd see him in court. He said, "You will die if you put the police on me." Showing their association, showing their agreement, showing their intention to participate in this organization, this enterprise through a pattern of racketeering activity. The evidence will show that while fellow associate Tinquarius Mender was an inmate at the Fulton County Jail, Mr. Mender, Mr. Huey, and Mr. Williams conducted a recorded video call wherein Mender relays he needed something and Williams pointed to Mr. Huey to take care of it. And then flashed Mender the YSL sign. You see, it's not a crime to flash a YSL sign. The evidence is going to show it's not a crime to participate in a video call. The evidence is going to show that it is not a crime to endeavor to provide something for a friend who's locked up in jail. All of that is okay. These acts aren't listed on the indictment because they're crimes. They're listed because they are actions. Actions that the legalese for is overt acts that reflect each of these defendants' tacit or unspoken agreement to participate in this enterprise through a pattern of racketeering activity, to be a part of this group, to gain ill-gotten goods through crimes listed in this indictment. I don't even have to use the word racketeering. I don't even have to use the word conspiracy. They endeavored to do some illegal stuff to get a bunch of stuff that didn't belong to them. And somebody, more than one, but all we need is one, the evidence will show that at least one person took a step towards furthering that goal. So when you get the indictment, after however long it takes us to get there, and you're looking at 191 acts and thinking, state, really?
I sustain the objection.
Thank you, Judge. I'm moving on.
Move on. That's argument.
The evidence is going to show that these steps that they took are akin to you just going out and get some toilet paper to further a conspiracy to go TP a house. Doesn't have to be a crime. It's just an act, an action. The evidence is going to show that the defendant Jeffrey Williams' words and actions also betray his participation in the conspiracy. I expect that you will hear from a YSL associate and member at trial that the defendant Jeffrey Williams rented a car. Notwithstanding that Jeffrey Williams had his own cars, but he rented a car, which happened to be a silver Infiniti sedan, that other YSL members, among them Demonte Kendrick and Shannon Stillwell, used when they openly and notoriously gunned down Donovan Thomas on January the 10th of 2015. The evidence will show that after that horrific act, I expect yet another YSL associate will come in here and tell you that Jeffrey Williams paid them money, gave them money to go to Miami and lay low in the wake of the Donovan Thomas murder. Later that month, on January the 26th of 2015, Demikion Garlington, who isn't before you for your consideration today, but who is in fact a YSL associate and co-conspirator of these defendants, he posted a video of the defendant, Jeffrey Williams, looking into the camera and saying these words. So, a nigga lied to their mama, lied to their kids, lied to their brothers and sisters, and then get right into the courtroom and tell the God's honest truth. Don't get it. Y'all need to get fucking killed, bro. That's from me and YSL. The defendant's words tell you that there is an enterprise. The defendant's words establish his willingness and agreement to participate in this enterprise through illegal activities.
All right, we got to fast forward through this bullshit.
Came and snatched me. I don't know, no point in asking. I was on what? Bleeding. Stuck like a magnet, bitch ass nigga. I shoot at your man, you need to stand down. I up my stamina, take it to trial. Get an appeal, take it to trial. Yeah, you're gonna whack them. Pay for that casket, that's just if we whack them. My young niggas pulling up. Bentleys, Austin Martins, rarest Teslas, strapped with an FN. You're gonna hear a lot about FNs. FNs galore. From here to 2015, FNs all throughout the incidents that are involving gang members YSL. Watch me whack that bitch. Pop him like assist. Glock with the assist. Incidentally, the gun at the home of Jeffrey Williams on May of 2022 that had been modified with that switch, it was a Glock. Again, we didn't chase the murders. We didn't chase the lyrics, rather solve the murders. We chased the murders, as the evidence will show, and in the process, we just found the lyrics. Jeffrey Williams' words and actions further reflect his agreement to participate in this organization through this criminal activity. He tells you, we committing them crimes. Hop out and shoot. Roll one up for the gang. He's not using gang colloquially. The evidence will show he's telling you they are a gang. You want to be slime? Children of Fulton County, go catch you a body. Me and Lil Bro. The evidence.
How would you expect the evidence to show, madam?
It is indeed, Your Honor.
All right, I'll overrule the objection.
The evidence will show that when Jeffrey Williams is saying me and Little Bro, we used to steal from the store, we had to stick it and go. He's talking about himself. The evidence will show that this is the man, through the music, that he has been blessed with the opportunity to be able to release and gain wealth from. Through that music, through that blessing, the evidence will show that Jeffrey Williams led the group of people that wreaked utter havoc on Fulton County. Jeffrey Williams' words and actions, as the evidence will show to the members of his gang, you'll hear in a conversation he has with them, y'all ain't beat him up or shot him yet, y'all is getting soft. The evidence will show that there's no place or need for that kind of edict or statement when all you're doing is making music. And to clarify and put a very clear and fine point on it, the evidence will show that no one is attempting to take away from Mr. Williams the fact that he has had a lucrative rap career. The evidence is simply being put before you to show that he is guilty of committing the crimes that are laid out in this indictment. That he and his fellow YSL gang members and associates on trial before you now agreed to participate in this organization through the illicit, illegal activity listed in this indictment. And that they further committed all the other crimes listed in the indictment beyond count one. Because as you'll see, count one consists of 191 overt acts. Acts that aren't all crimes, they're just acts. But counts 2 through 65, the ones that have these defendants' names on them, are the ones you're here to evaluate whether or not the state has proven. Actions and words, words and actions. The evidence will show that this was Donovan Thomas in life, that on January 10th at 2:15, about 7 o'clock in the evening, Donovan Thomas was living his best life. He was up at the barbershop at 330 McDaniel Street. He had paid for a bunch of people, a bunch of kids to get their hair cut. And you'll see that he is out there enjoying himself. The last actions that he took while he was fully alive and healthy, joking with his friends. You'll see that they didn't even see it coming. You'll see evidence that Donovan Thomas was literally in the middle of lapping it up with his friends when a car drives by and opens fire on him and whoever else might have been in close proximity to him. The evidence will show that this act wasn't done secretly. It was done openly, notoriously, almost as if to send a message. We did it. The evidence will show everybody knew who did it, because it wasn't done secretly. The evidence will show that this act didn't happen in a vacuum. There were things that led up to it. An argument at Club Crucial or Club Brucial, as my defendants may like to say, that involved a YSL associate by the name of Kenneth Copeland and a member of a rival gang. Kenneth Copeland gets jumped. He's flashing money because that's what they do. It's ladies fight night and they're out there flashing money. Kenneth Copeland gets jumped. Diamante Kendrick jumps into action, goes to Kenneth Copeland's defense, punches out a member of the opposition, and then shots are fired. Shell casings. Shell casings are all throughout the evidence that you'll see and hear in this case. Remnants of the violence inflicted on this county by YSL and its actions. Shell casings are fired in between January the 6th and 7th of 2015 and January the 10th. Other incidents take place and they lead to the ultimate gunning down of Donovan Thomas. As the evidence will show, in the ensuing months, there were a series of shootings and retaliatory shootings. Most notably, The mother of rapper Rayshawn Bennett gets shot. Her house is shot up twice. She gets shot one time. And the evidence will show that there is not always cooperation, because there is a code that people adhere to when this type of violence is surrounding them. No snitching. So the evidence will show that even as people were getting shot, even as people were bleeding, even as people were being taken to the hospital to have their wounds attended to, they weren't always forthcoming. They weren't always willing to talk to and to trust law enforcement, not even if it would serve their own purposes. The evidence will show that members of YSL ultimately, as a result of those shootings and retaliatory shootings, ballistics or firearms matches started coming back to various people. And then one YSL member, when Quindarius Zachary, he gets caught with a gun, the shell casings from that gun go to match some of these shootings. Quindarius Zachary is caught. He starts telling. The evidence will show that Quindarius Zachary was a straw purchaser for YSL. A straw purchaser is nothing more than somebody who goes and gets guns for somebody who's not supposed to have them. And that's what Quindarius Zachary did. Firearms found in the hands of Kenneth Copeland led to further revelations to the police and law enforcement. The evidence will show members of YSL were so eager, so gangster about acting on behalf of and in the protection of the defendant Jeffrey Williams and YSL, that when Wayne Carter, otherwise known as Lil Wayne, came to town to perform at the compound while the defendant Jeffrey Williams was performing in Lil Wayne's hometown, according to word from the people that talk, getting booed at the time, members of YSL show up at the compound, locked and loaded with guns. Evidence will show that security knew to be on the lookout for members of YSL. The authorities were alerted to ongoing public rifts and back and forth between the defendant, Jeffrey Williams, and members of his gang, and statements being made publicly on social media about, towards, and threatening Wayne Carter. So when Tyrone Dennis, who is working an extra job, he is a law enforcement officer. At the time, he was an investigator with the Atlanta Police Department gang unit. So when he's there working his extra job, and he sees Walter Murphy, one of the founding members of YSL, show up with the defendant's sisters and Trontavia Stevens, and ultimately Jimmy Winfrey with guns. When he sees Walter Murphy try to secret a gun underneath the wheel well of a car, he calls him out. He's like, "What are you doing?" Walter Murphy's like, "Oh, hey. The evidence will show that the YSL gang members that showed up at the compound that night were not allowed entry into Lil Wayne's concert, his venue. So what they did was they waited until Lil Wayne leaves, gets in his tour bus, and is attempting to leave the area. They get up beside the tour bus and they unload bullets into the man's tour bus. Bullets. For nothing, except to show their dominance. There will be no evidence that Lil Wayne threatened either of them that night. But that act on the part of Jimmy Winfrey and the defendants before you today, that act was intended to show their solidarity, their willingness to act on the behalf of, their willingness to exact violence upon anyone who threatened the position of the criminal street gang calling itself Young Slimelight. You'll hear evidence that after being arrested, or actually when he was approached back in 2014 about an armed robbery he allegedly committed, YSL member and associate Trontavia Stevens was seen bearing tattoos on his hands, ROCCREW, Cleveland Avenue. And that on his side, he had YSL. And Detective Mark Belknap inquired of him, what's that? Though Belknap knew, because he had been working in the streets of Atlanta for a long time. He was familiar with RICO. But as gang investigators, they're taught to interact with and talk to people when they see indicia of criminal street gang activity. You'll hear that Trontavia Stevens told Belknap, well, Rock Crew is the name you used to call ourselves. Then we started going by YSL, which stands for Young Slimelight, or it did stand for Young Slimelight. But then, when my friend Jeffrey Williams started becoming successful, we changed that name to Young Successful Life. The words of a member of the gang himself. The only time, as the evidence will show, that members of YSL don't want to call themselves and acknowledge that they are in fact a gang is when it would be to their detriment. The evidence will show that any other day of the week, they are loudly and proudly promoting their criminal activities. Donovan Thomas, he was driving this Chevrolet Tahoe the night he was gunned down. The evidence will show that this location here is the barbershop right up from the Texaco at the corner of Daniel and Northside Drive in Atlanta, Fulton County. We asked you during voir dire, you heard us say how many of you are familiar with this area. This is that area. The evidence will show that that is the way that Donovan Thomas looked last time his loved ones saw him. That his life was swallowed up in that crater created by YSL in the Cleveland Avenue community. And the words that they found while looking into this murder, spoken by members of YSL. We don't speak about shit on wax, but indeed they do, as the evidence will show. They just kind of thinly veil it. We are known to kill the biggest cats of all kitties. Donovan Thomas in the community, he was a big homie. He was a friend to a lot of people. He was a big deal. And it touched a lot of people, as the evidence will show, when his life was taken. The words that were spoken, we known to kill the biggest cats of all kitties. How coincidental that Donovan Thomas was gunned down. And these were the words later spoken by members of YSL. The evidence will show that it's not coincidental at all. 100 rounds in a Tahoe. 100 rounds in a Tahoe. The evidence will show that the lyrics released by YSL members, the lyrics they chose to speak, they bore a very eerie significance to real life. 100 rounds in a Tahoe. And you'll see that Donovan Thomas's Tahoe had bullet defects all along the back of it when they sprayed Donovan Thomas and his car on January the 10th of 2015. This that slime shit, killing 12 shit. The evidence will show that 12 is the word that is commonly used to denote law enforcement. And speaking of the young people whose innocence and whose lives were swallowed up by that crater created by YSL, Christian Evinger. He's not before you today, but he is a co-conspirator of these defendants. He is a YSL member and associate who got YSL tattooed on his face at the tender age of 15. He repped YSL continuously and notoriously throughout his social media. The evidence will show that at the age of 16, he, along with an accomplice, robbed a young woman by the name of Taradia Hill at gunpoint in front of her child. And that at his sentencing hearing, Taradia Hill, seeing a young black boy, who could have been her brother, cousin, she actually advocated for Christian Evinger's lenient sentencing. So Christian Evinger, he wasn't sentenced on what he was originally charged with. With the acquiescence of the victim, Christian Evinger received a lesser sentence. He went to prison for a short time, and within less than a year, he committed an armed robbery. And when law enforcement officers are out there looking for Christian Evinger, who incidentally constantly posted on social media with guns and gang signs and the green emojis with the gun pointing to the camera or to some other emoji talking about how he reps hard for YSL. When law enforcement officers, specifically a law enforcement officer just 30 years old by the name of Officer Rogers, when they go to apprehend Christian Evinger on this armed robbery he committed after being released from prison, having robbed Taradia Hill, they do everything they can to take him in without causing any harm to Christian Evinger. But you will see that while he's being taken into custody, what Christian Evinger does, he takes the firearm of this young officer. He pulls it out of the holster and he fires, putting 7 bullets in Officer Rogers. The evidence will show leaving a law enforcement officer with PTSD after he is tried to humanely apprehend a member of YSL. The evidence will show that this person depicted here is Fontavious Greer, also an associate, but perhaps more importantly, the brother of the defendant, Jeffrey Williams. Christian Evinger was so deeply entrenched, ingrained with loyal to YSL, he's even posted free uncle bitch as Fontavious Greer served a sentence for murder. Who said they want smoke? Christian Evinger, as he's calling himself YSL Briss. Note that Chris does not start with the letter B, but it does when you're associating yourself with a criminal street gang who aligns itself with the Bloods. And that's the tattoo that Christian Evinger on the side of his face proudly publicized on June 27, 2015. He wasn't even 16 yet. New ink with the green snake emoji and a red heart. The evidence will show that though you'll hear over and over the names of the 6 people on trial before you today, that the 6 people on trial before you are not the people who were most viciously affected by the acts of this criminal street gang. The evidence will show how far members of YSL are and were willing to go to act immediately on behalf of each other. Dexter Montgomery, minding his business, happened to drive in just a little too closely behind another YSL associate. who then phoned up the gang who was posted up at the trap house. And in minutes, 2 more YSL associates showed up with a long gun and handguns. Dexter Montgomery had no idea he was about to lose half of his head that day. As Dexter Montgomery left the gas station, 2 YSL associates followed behind him. And as he stopped at a red light, they opened fire. Miraculously, the evidence will show that Dexter Montgomery survived, but literally half of his head is gone. You'll hear from and see Dexter Montgomery during the course of this trial. The evidence will show that after that happened, law enforcement, at first it wasn't the gang unit, but the gang unit recognized some of the players, Walter Murphy, other members of YSL. And so they began to assist in the investigation. And they learned. The YSL gang member said, we got a call that one of us needed some help. He didn't know who this was pulling up behind, so we just responded. You'll hear that investigators gave their hand and said, well, wait a minute, did you know what you were responding to? They're like, no, we don't have to know. If our boy need help, we're gonna respond. They said, well, where'd you get the gun? Oh, they're by the door of the trap house that we were in. They're just there, ready for us to use when we need to. Their words, I can't make it up. The evidence will show that actions of YSL gang members and associates on behalf of their leader when they felt someone disrespected Jeffrey Williams or any other member of their pack. They made threats. Not quiet, whispered threats, loud, public threats with wide, vivid displays of firearms. We're not going back and forth. There's got to be some Biggie and Tupac shit and shooting up Wayne Carter's tour bus. The evidence will show that all of those actions, they're not elements of the offenses that are charged in the indictment. We don't have to show those things in order for you to find them guilty, but the evidence will show that those things prove the existence of the conspiracy of the agreement itself. The agreement on the part of these defendants and other charged and uncharged co-conspirators to be a part of this organization known as Young Slime Life through a pattern of this illegal activity outlined in the indictment. There are numerous victims that you're going to hear about. Shannon Stillwell is another defendant who is before you, being accused of various crimes in this indictment. Shannon Stillwell is alleged by one of his own crew, by another YSL, 2 other YSL members, to have been one of the gunmen who took the life of Donovan Thomas. The evidence will show that Shannon Stillwell was arrested. He was arrested after some investigation by the Atlanta Police Department. The evidence will show that the information initially relied on by that first arresting officer, it didn't pan out to be actually accurate. So when the case got to the district attorney's office, more investigation was conducted. The evidence will show that the office didn't just take the word of the person who originally identified certain people as having committed a murder of Donovan Thomas. Instead, as the evidence will show, what our office did was dig to find out whether the people who were talking were actually in a position and a place to know the stuff that they talked about. And what they learned was that that person originally relied on by Investigator Thorpe, that person was just lying. And so the people that Investigator Thorpe originally arrested on the Donovan Thomas murder, they were released at various times on bond as the office continued to investigate further.
God, this opening statement's long as fuck. I don't know how these jurors pay attention to this shit. Good Lord, it's long as hell. I don't know. I'm about done with it. I know that. We're about to have to just catch up on our own, and we'll pick up tomorrow because this is a lot of shit. and I got stuff I got to get done, so I'm not gonna be able to stay on here anymore. We've been on here 3 fucking hours, and she's still yapping. Fuck, I don't know. I'm not gonna be able to do this. This is probably gonna be a little bit too long. I mean, she's still going, and we still got 2 hours left of her fucking shit. Well, I guess we got 2 hours. Let's see here. Then we got nothing. Then we got him picking up. And then let's see here. Him talking for a little while. Opening statement. Well, I know Burnt Toast will be live tonight. She's going live at 7:30. Right, you can start reading Jungle Book yourself. Yeah, it's she's very long-winded for sure. Shit. This is ridiculous. I know that. But anyhow, you know what else we can do if you guys want to catch up on that instead of catching up on the like going through all this or whatever, we could just do like the key points. Like the highlight, right? Like the highlights. That's what I was just thinking, Denny. We can do the highlights of this or whatever. And then I have this too that we can go over, which is the all the paperwork, the indictments. So we could go through these too. You know what I mean? There's 88 pages of them here, so it's got everything in it too. So I figured that'd be interesting to go through. You know, it'd give us something to look through, anyways. But I appreciate y'all hanging out. I'm getting sleepy and I got stuff I got to do. I've been in here trying to clean, been sleeping, mopping, doing dishes, things like that while we've been on here doing this and trying to keep up with it and listen at the same time. So I don't know, Twist. I'm not sure if they know what a trap house is, but shit, we're about to do some PowerPoints here and figure it out, get down to the bottom of it. Hi, B Tim. I hope you had a good day at work, man. Anyhow, I will catch y'all on the flip side. Alicia's over there laying it down. She's putting some facts out. If you guys get bored, you want to go over there. She's live now. And Burnt Toast will be live with I believe she's doing Betty's rants from today. So if you need something else to watch, she'll be live in about 2.5 hours my time. I'm thinking. So anyhow, I hope y'all have a good night. I'll catch y'all on the flip side. I love y'all, my beautiful peeps.